Welcome everybody to the Lex Africa seminar on the global pandemic, dealing with is your business safeguarded against emerging technological threats. So thank you very much to everybody for joining us, and thank you very much to our panelists. On our panel, we have the esteemed Alice Namuli-Blazovic. She's an award-winning lawyer. She's an international speaker, author, and partner at Katende Sempebwa & Co., associates in Uganda. Alice specializes in technology and the law and has a keen interest in artificial intelligence, blockchain, cryptocurrencies, fintech, cyber law, and data protection. We also have Danielle Mukuri, who is the managing partner of D. Mukuri and Partners, which is a leading law firm based in Cameroon and ranked by Chambers and Partners, the Legal 500, as well as IFLR 1000. Danielle is a member of the Cameroon Bar Association, the Nigerian Bar Association, and the American Bar Association, and specializes in business law, a harder corporate law, and financial technology law. We also have Fayaz Bojani. He is the managing partner of FB Attorneys in Tanzania, with 20 years of experience in corporate legal affairs, and he leads the firm's litigation team. His practice spans a number of sectors, including the financial services, telecoms, energy, mining, tax, competition, and M&A. And we have Nelly Tiago Njinka. She's a partner in the commercial and corporate law department at Scanlon and Holderness, which is a leading law firm in Zimbabwe. Welcome to the panelists. Right, if we can jump to the questions that we have set forth to be answered by each of our panelists. The first question that we have for the seminar today is, what emerging technology have you noticed is being adopted generally in your jurisdiction as a result of COVID-19, and why has the need arisen, and in what way is this technology assisting users? Alice, I'll hand over to you first.
Thank you very much, Natalie. Yeah, it's on mute. Thank you, Natalie. I can hear you.
There you go. Thanks, Alice.
Okay. Yes, thank you, Natalie, for that question. Well, within Uganda specifically, I would say it's mainly blockchain and AI, artificial intelligence. And I would say majorly in the financial technology sector, we have seen pretty much a growth or a spike in growth over several fintechs. And these are companies that transact payments or have payment platforms across the continent. There has been an increase, a huge increase in transactions, payment transactions online, whereby so many people felt that this was basically the best alternative to transact money. The fact that we're not able anymore to to go out. Like in my country, we had like a complete lockdown. You couldn't even move, you couldn't go to your bank. So basically online platforms turned out to be the best alternatives. And when it came also to financial technology, this turned out to be like the biggest industry that definitely has boomed and has benefited so much from this. And most of them, like I mentioned earlier, these are all, most of these are fintechs using a blockchain-based technologies to transfer, to make these payments.
Hi, Danielle. Sorry, I was on mute there. Can you give us a perspective from Cameroon, please? And thank you to Alice for your insights.
Okay, can you hear me, Natalie?
Yes, I can hear you perfectly.
Okay, so definitely, as Alice was saying, fintech has actually proved to be the widely adopted branch of technology in this part of the continent too. And I would like to go a bit out of the scope of the COVID-19 crisis to say that in the last 2 years, fintech has actually been the most, dynamic branch of technology law in the CEMAC zone, that is the Central African Economic Zone. And it goes to say that even in terms of the regulatory framework, it's that branch of technology law that has the most comprehensive regulatory framework in Central Africa. And with the COVID-19 crisis, the CEMAC regulator came up with another piece of legislation that is to, take another opportunity to put fintech at the forefront of the financial inclusion strategy in this part of the continent. So in the month of April, there was a new release from the governor of the central bank indicating that interoperability of in-payment systems is now effective in all the CEMAC zone countries. That is, the 6 Central African countries in the CEMAC zone can now transact from bank accounts to online payment accounts and to mobile money accounts. So that was kind of huge, improvement in the system due to the COVID-19 crisis. That is to avoid people having to handle cash, and also, to allow people to enable people to comply with the social distancing measures. So fintech is definitely the number one.
Yeah, I think that's exactly right. I think we're seeing a lot of that most unexpectedly, particularly given the situation that we find ourselves in. Mayaz, if I can turn to you, if you can give us an indication as to what you're seeing in Tanzania.
Hi, everyone. Just before I start, I want to protest about the serious gender imbalance on the webinar. I don't know how I should protest, whether it's by way of petition or otherwise, but thank you very much for joining, and to my colleagues. So in Tanzania, we've seen, and I'm looking at it from the legal perspective, we've seen the courts trying to adopt video conferencing, and the virtual court system has kind of started. We've had a couple of Court of Appeal sessions in criminal cases where the courts have actually adopted video conferencing with the remandees in prison. So that has been very good. And the famous technology that we all know about, Zoom, is booming. I was just looking at The Economist and the New York Times, and Zoom, which was founded only 9 years ago, has a market capitalization of over $50 billion, which is, it's only a 9-year-old company. And John Deere, the famous company founded 170 years ago, has a market cap less than Zoom. So Zoom is booming, and we have adopted Zoom just as we have here. So the courts have adopted Zoom, so that's one of the technologies that has been adopted. The other one is we've seen electronic filing, which has been introduced. In fact, it was there. It is more prevalent now. We have a very creative Chief Justice who leads the judiciary, who is doing the best within the allocated budgets to electronize the systems here. So yes, virtual courts and electronic filing has taken off here in Tanzania. Yeah, that's it from here.
That's excellent. That's good to know. Nelly, what are you seeing in Zimbabwe?
So unlike the rest or most of Africa, we already had a cash shortage. So we were already into mobile money, electronic transfers, and all of those things. Whilst everyone else is experiencing it for the first time, this is something that we'd already started doing. What we are seeing, though, is maybe refinement of the processes, because the volumes have increased due to the fact that you can't walk into a bank and do what you would normally do in a bank. And most of our banks are preferring to have less branches so that people make use of those online platforms. I'm just responding to what everybody else has been saying. And just because there's COVID, it doesn't mean that the laws are not being applied. So our anti-money laundering laws are still being applied, looking at suspicious transactions, reporting of suspicious transactions, and the like, and proceeding. And I'm sure post-COVID, I'm hopeful that we'll have a very good system in place. So national payment systems platforms, for me, are things that were there in the past, but just being refined as we go on. An interesting area that seems to have increased at present is the use of telemedicine, because people can't easily access hospitals, clinics in the fashion that they used to. Some medical practitioners are afraid because we don't know who has and who doesn't have COVID. I'm sure you all know that some of the testing systems for the COVID virus have proved to not be as conclusive as would have hoped for. So everyone is acting or treating each person as potentially a live COVID matter or COVID infected person, right? That's for the protection of the health practitioner. And telemedicine was not something that we had as people love going to see their doctor and talking to their doctor and then getting treated by their doctor. Your doctor becomes your friend. So now you can call your doctor and get your telemedicine treatment even via the phone, your prescriptions via the phone. And we also have, I love this call center that's there. It's always been there, but now it's more active because of what's happening now. They call it 2019. It is a Ministry of Health telecenter, which is being supported as well by the private sector, and they collect all data. So if anyone feels as though they're not well, they will just call and explain their symptoms until they're put to a medical practitioner who is suitable for the type of symptoms that you present. But what is being discovered is that this is being used even as a reporting mechanism for personal security issues. So you're immediately connected to the emergency personnel that you require for your issue, whether somebody's threatening to harm you, whether your house is burning, all those things. So it's working out as a platform to do much more than just provide telemedicine. Hopefully, with all the data that's collected, we'll be able to also isolate areas which are rife with particular pandemics, whether it's malaria, cholera, typhoid, COVID, and then set out resources appropriately for those areas and make sure that you can prevent things like malaria, make sure that we prevent things like that from spreading unnecessarily. So it's exciting, and you can tell by my speech that I'm passionate about that part of the tech side, the telemedicine platform. The rules still apply. All the health practitioners will have to comply with what they have agreed to. Make sure you keep confidential the information that you collect and treat your patients as best as you can. Yeah.
That's excellent. Great. Thanks so much, Nelly. I think we're going to start unpicking the various issues now that we know sort of what's been profiled in each of the countries. Alice, if I can start with you. In terms of utilizing the particular emerging technologies that you were seeing in Uganda, what are the three things that you think people should be aware of in terms of utilizing that particular technology? What are the three most important things or the three most critical things to consider when utilizing a particular technology?
Definitely have, sorry.
Thanks, Alice. Yeah, I can hear you.
You can now? Okay.
Yes.
Security, I would definitely say security risks due to the increased use of or the increased use of various technologies at home. Of course, this again was brought about by the impact of COVID, like Faiz has said. So we've seen so many people, of course, using platforms like this, Zoom platforms, which have made have created some kind of vulnerabilities to so many, like several businesses in terms of cybersecurity. And for this particular period, I would say for the last 3 months, there's also been, according to the statistics available on the continent, there has been like a high increase in cyber attacks, cyber crime. And this has mainly been because of the fact that most of the cloud systems that are being used by most of the businesses are not secure. Many businesses are not aware of these vulnerabilities. Most of their employees have, due to remote working, ended up using their personal gadgets like personal laptops, where of course they end up actually sharing them with either their family members or I mean, just leaving them around for anyone to use their passwords, and also just moving around office information from one gadget to another without being very aware of the vulnerabilities. Many of the businesses staff are not trained in this kind of with this kind of risks. So we have seen definitely an increase where so many businesses, of course, information has been hacked. Luckily enough, some of the information that has been hacked, like to really great amount, has not been has not caused substantial damage. Just to some of the businesses, definitely we represent, and we've tried to go out as much as possible to reach out to our clients and make them aware of these security threats that definitely they are facing or they have faced.
That's excellent. Thanks, Alice. And I suppose, the items such as, as you talk about the interchangeability of laptops and the settings that you have, which may actually reflect as you doing certain things on your laptop, and when it's actually somebody else, it's another user, and it's then attributed to you and your action. So you would then, become liable to the extent that there is liability that attaches to the activities in your personal capacity. So that's a very real risk, and thank you for highlighting that. Danielle, in terms of some of the technologies that you've mentioned as using in Cameroon, what are some of the highlights and things that you think users need to be aware of? Danielle, I think you're on mute.
Can you hear me now?
Yes, great. Thanks, Danielle.
So now that it has been made possible and effective for people to transact from their bank account to the mobile money account, or even make payment through online payment platforms, the major risk is a security risk. So now the question users need to ask themselves is, how secure is the online platform or the online payment platform I'm using? And also, how secure is the network I'm using to transact? So those are the major issues that take us to the question of how to choose your operator. It's very important. So not all operators are actually authorized to operate in Central Africa. There is a license to operate as is the payment services provider. So you need to make sure that's something as a user you need to do before you decide to deal with the payment service provider. You need to make sure he is a licensed service payment provider, and also that he has he has undergone the scrutiny and the screening to be able to operate as such. So that is something that needs to be considered by the user. And the other aspect of it, when you have already started dealing with the operator now, you need to make sure that your data is protected. And how sure are you about your data protection is through the consent you give. In Central Africa or in the CEMAC zone now, it has been made mandatory to duly seek and obtain the consent of the user before using the data. And that consent should be obtained through writing. So even if it's an online agreement, you need to make sure that you approve it, that you have actually given your consent as far as the use of your data is concerned. So those are the two main issues to be considered when it comes to transacting online.
Excellent, thanks Danielle. So far we're seeing trends in terms of cybercrime, and we're seeing trends in terms of consents, particularly for data privacy. What are we seeing in Tanzania, Fayaz?
The advantage of addressing you third is everything gets covered by the first two. So now you know why I was saying I'll be third. And then I obviously will assist Nelly from Zimbabwe. Okay, so 3 things that users of emerging technologies should be aware of. First, digital rights. I think confidentiality, privacy, and limits of the freedom of expression. Second is cyber crimes, issues with impersonation, unsolicited or spam messages, illegal interception of communications, invasion of privacy, illegal access, illegal interception, data interference, your intellectual property rights could be violated, system interference, cyberbullying, and the list goes on and on, of course. Third is confidentiality. I think the issues of confidentiality people have overlooked with this Zoom era, and you could have anyone listening to you. It's a very difficult position for many clients as they're unsure whether to agree or not, for example, to online arbitration, as most arbitrators are closed doors. I mean, most arbitrations are closed doors, and the question the client asks you is whether or not the doors are closed when you arbitrate online. And the answer is no. I don't think there is enough security online at the moment. The COVID came in very quickly, and the Zoom's confidentiality and the encryption, as they call it, has not kept up to date. So I think these are the three things that users of emerging technologies should be aware of.
Great, thanks, Fayad. And I think you're 100% correct in terms of the platforms that you're utilizing and making sure that your platforms are secure. And to the extent that they're not secure, being aware of the type of information that is capable of being disclosed and to whom. So some of the things that we have seen here when we've had our parliamentary sessions and we've had presentations and we've had speeches from our president is we've seen the interruption of the Zoom conference call that's happening in the background. Some of the hackers have hacked into that, and the various images have been displayed and exposed. And I think that's obviously something that we all just need to be very cognizant of. So encryption, absolutely, protecting the data, what data you are and is available, making sure that you have the consent to have that data, and then also just making sure in terms of the payment systems that were mentioned as well, making sure that those operate safely and securely, so that when you do transfers of money, you're fairly certain, well, almost 100% certain that you're going to be receiving your money. Because particularly now what we're seeing in this massive economic crisis due to this pandemic that the flow of money is even more critical, and cash is definitely not king. We're seeing electronic cash and digital cash sort of coming to the fore in terms of the utilization. Nelly, what are we seeing? Is anything in addition that we're seeing in Zimbabwe that's cropping up and is of critical importance to keep in mind?
Well, from a Zimbabwe perspective, I think the three things someone should be aware of as a user is the fact that data is protected, and that there's specific protection. There's also general protection that is afforded to. There's also general protection that is afforded to the public in terms of access to information, the rights of the disclosing party, and personal data protection, which is enhanced by our laws. The other thing is the incoming data and cybersecurity law, which people must be aware of. The present Postal and Telecoms Regulatory Authority is going to also take over the issue of data protection and cybersecurity. They will provide for and investigate cyber crimes, and they'll also provide standards for collection of data safely and even a safe technological environment for our country. Now, the third thing for me is what is expected of me and of you as an individual, as a corporate citizen. Of course, you have to know the laws, but you also need to know the laws about the collecting and processing of the data, and that it is regulated. Also, that it is a criminal offense to abuse data and to even use it to cause despondency. As an officer of a company, a corporate, it's very important to know what the data and cybersecurity policies of your entity are. If they're not there, make sure that they're in place. We need to protect data from being leaked, because this also has a negative impact on the goodwill of any entity.
That's great. And so I think we're seeing pretty much the same thing. It's data privacy is of paramount importance, consent to whom the information is going to be made available, and the laws governing that. So given that in mind, how do users of this particular technologies, of these technologies that we've mentioned, what are the kinds of risks that they face? And in terms of those risks, if they do not take steps to mitigate against those risks, what are the types of liabilities that are attributable to utilizing these technologies and not taking steps to guard against, for example, data privacy, a collection of data, the encryption of data that you have. So what are we kind of looking at in terms of the local statutory regimes? How do they protect themselves, and what happens if they don't? Alice, if I can ask you to respond first from Uganda.
Yeah. Well, definitely it would be data breaches. This is something that I know so many African countries right now, about like 27 countries, African countries have data protection laws. And we also have an African Union data protection cybersecurity framework, which definitely requires us to follow certain guidelines when it comes to protection of data, especially personal data. So when you talk about what should these companies definitely do, I think first of all they should first check their procedures, review their systems, and just find out do they have actually the right consent. If that consent expired, can they renew it? How can they? And what is acceptable consent? Is digital consent sufficient? Should it be manual? And that consent, is it translated in all the languages that all the data subjects are able to comprehend? And of course, in case of a data breach, this has to be reported within a certain period. That, of course, is extremely key. Because most of these regulations actually on the African continent are quite similar, as most of them were benchmarked on the GDPR, which has turned out to be, like, I think, the one with the most stringent requirements. So I think the most important thing, what I think companies or businesses should be aware is that do they have the procedures or a data policy in place, and are their staff are trained, aware of this kind of data breaches, and also in case of a data breach, what they should do, because that's extremely important. In Uganda, you're supposed to report data breach within a certain time, a certain period, like let me say 30 days, to the regulator, and failure of that, or if the regulator actually finds out or someone else notifies them, you're required to pay 2% of your annual GDP of any company, or you're liable to some term of imprisonment. So you wouldn't want to go, to that extent. The most important thing then would be putting in place data privacy policy, and also to hire the cybersecurity experts who can be actually able to help you keep note of these kind of loopholes where you would be, cybersecurity experts and data protection, what you call data protection officers or experts, who are able to identify these loopholes where data can easily be leaked or hacked.
Thanks, Alice. That's very interesting to know. So there is actually a statutory penalty that will be levied on somebody who has not taken the required steps to protect the information that they are receiving. Also, I think it would not only be in relation to the consent to receive that information and what constitutes consent, but also what they're going to then subsequently do with that information. So to the extent that they are vulnerable and they are subsequently then attacked, the information is then made publicly available or is utilized by somebody who is not authorized to use that information, that liability then does attach. And it seems to me like it's quite a steep penalty. So I think it's good that people are advised that this is something that is required. Danielle, how what are the issues that we're looking at in Cameroon, and how are these treated from a statutory perspective?
In Cameroon and in Central Africa in general, that is the entire SAMAC zone, there is this tendency, of quickly using what is trendy. whenever there is a new concept, you have this, tendency of jumping into it without actually considering the terms and conditions. So I would like to draw users' attention to, the necessity of getting familiar with the terms and conditions that apply to the various payment services they decide to use. Because the law is different according to the type of payment service to use, and also according to the operator or the network providers, the payment service provider involved. So the actors are different. So you have several actors in the industry now, and not the laws applicable to them are not the same. You have some little differences, and also the laws applicable to the various services they provide are not, the same. You have some differences at some points. So I would like to draw users' attention to the necessity to get familiar to the, the specific terms and conditions applicable. And also, they should also subscribe to, notifications for everything that has to do with failure in the system, for everything that has to do with suspicious activity on their bank cards, on their platforms, and also on the mobile money accounts they are managing. Because recently, and this actually happened last month in Gabon, which is a Central African state, one of the leading banks in Gabon, BSIC, was actually a victim of a cyber attack. So almost more than 8,000 transactions were carried out from Mexico using approximately 200 bank cards of Gabonese, depriving them from more than 100 million CFA francs in their accounts. So maybe because, okay, you got to know that I can use this platform to buy, I can use this platform to make payment online, but you don't really get familiar to the terms and conditions that apply. And also when there is a suspicious activity, for example, if you did not subscribe for notification, or you are not that regarding in terms of the changes or the suspicious activity you may note, you may easily find yourself in a situation where your data gets used or easily hacked without you knowing. So the other aspect of it is that it's also important to know the timeline applicable in terms of reporting. To report a suspicious activity and make sure that liability arises, you need to make sure there is, if there is a timeline to be observed, that you actually reported the activity within the time frame to enjoy the benefit of your claim. So those are the issues users should actually consider.
Right, thanks, Danielle. And I think in terms of where we're going to go next, for our next question, I think we can get into the flesh in terms of what the actual timelines are and what happens if you don't comply with those timelines. We normally find that whilst a pecuniary penalty is quite a deterrent, any sort of criminal liability that would attach to any of the activities, or any particularly jail time, that tends to focus the mind. Fayaz, what are we seeing in Tanzania on the same?
So, yeah, Natalie, the biggest risk on the light side is, I'm told, that when you are online and the cameras recording you, you look 10 kilograms bigger. So that's a very big risk for people who are trying to lose weight. It can lead to depression. You might want to sue Zoom and the others. I think a software needs to be developed where the kilo checks can be done online. So that's the lighter side of the risk. Okay. Now coming so that's a big concern for me because I'm trying to lose weight, but that's a different story. Okay. Now I come from the arbitration and the litigation angle, so you'll excuse me for giving examples from that angle. But for closed door matters like arbitrations and mediation, there's always a serious risk of information leaking or being misused when you're doing things online. There's nothing like a foolproof way of conducting arbitrations online. That is a given. You don't know who is listening, what ear they're listening with, and with whom they are listening. There could be someone else in the room, you don't know that. You don't know whether your competitors are monitoring you and what you are doing. It is not easy to convince a client to produce evidence, for example. Take an example of a company which is not public and the financials are very dear to them. So the financials of a private company being used as evidence online is a very challenging for us as lawyers. Now, the question, however, is how do you go about protecting yourself? If you need to seek authority before producing something, it's a good idea to do that. Sometimes we've seen clients not seeking authority because they know it is a closed door arbitration, but you never know how that information goes out. So if something needs authorization, make sure you seek it. Secondly, you can insert some heavily worded privacy and or confidential clauses in your documents to build a good case in case there is a breach. However, by then the damage is already done. So it's only so it could be looked as a deterrent, but it is a challenge. The third one is passwords, backing up data, using secure networks, and separating devices that are used in the office and at home, although it is not easy to do so. We all talk about it, but I'm sure if you take a quick survey here, many people will be using the same device. On what liabilities arise, mishandling of documents may make them inadmissible in court in certain instances. Of course, mishandling of sensitive data has criminal implications as well. Remember that everything cannot be 100% confidential. Under law, you might be forced to disclose a few things. And moving digitally in a reckless manner may also increase contempt of court claims. So these are the three liabilities that I can think of. Hence, the advice is to move cautiously. And the old aphorism that says, all that glitters is not gold, is as valid today as it was 600 years ago. In short, adopt technology, but do so systematically, cautiously, and based on your need.
Excellent, thanks, Fayaz. I think that's some really good advice, and I think we all land up in a scenario where we tend not to be as vigilant as what we ought to be and read the terms and conditions, because we want to use the technology really quickly, and we want to be up and about and be able to access the technology without having to go through the complete pain in the backside, to put it mildly, of having to go and read through all the terms and conditions, which sometimes are extremely long. And if they have been drafted, elsewhere in the world,
font is small, and the
font is tiny.
I mean, if
Correct.
Zoom is asking you, do you want to log in online, and then says, please read the terms and conditions below before you. I mean, I think 100% of people who want the free Zoom will just click on it, and then you've got everybody, including the Lord and the Prophet and everybody else hearing you, not knowing that. So it's a big challenge.
Exactly. Okay, Delhi, from your side, what are we looking at in terms of what's going on and the liabilities that are attributed to various activities that are potentially not lawful or borderline in terms of the legalities? What are we looking at there from Zimbabwe side?
So, the dangers of always being the last one. Everyone steals all your points. So I think for this one, I'll speak to what we have in the Consumer Protection Act. Now, under this act, it is the duty of any person who receives, compiles, retains, or reports any confidential information pertaining to a customer, even a prospective customer, and you have the duty to protect such information. If you release or want to release this information, you need to get the express consent of the customer and of the prospective customer. It is an offense under that act to use that information unless the disclosure is in compliance with regulatory issues or for proper administration of the Consumer Protection Act. Now, the penalty there is pretty amazing. And I don't know, depending on the currency, you may get a scare or you may not. So in the event of a breach, there's a fine of up to 2.5% of the respondent's annual net profit of the year, or any amount that the court will decide is supposed to be imposed for that breach. And under the Act, employees and employers are jointly and severally liable for contravention of the confidentiality provisions.
Wow. That's excellent. Okay, so we're sitting in an environment where there are regulations, maybe not specific regulations for particular technologies, but there are some forms of protections. So if we now look at what the regulations in your jurisdictions do, what are the protections that are afforded to the users of the different types of technologies? And here we can look to issues such as, utilization of blockchain or cryptocurrencies, even in terms of national payment systems. What happens if you use Zoom? And what happens if your information is leaked? It's very difficult when you are utilizing an app, particularly, to have recourse to the designers of that app, because in a lot of instances, there are no sort of contact details. There's no way that you can deal with anything specifically in relation to an app. So I think there are some issues that are worth having a look at and that we are grappling with in terms of these emerging technologies. The use cases are phenomenal. We see exactly how they facilitate our lives. But in terms of regulations, what protections do we have very specifically, given the technologies that we've already discussed, in terms of utilizing these technologies? Yes, buyer beware, and yes, we have all of the carve-outs in terms of you need to know and understand the terms and conditions of utilizing a particular app. However, what happens if you don't read those? And what happens in circumstances where the information is leaked? Is that a get out of jail free card? Do you have statutory protection regardless of what the parties agree in contract? Those are the types of things that I suppose that become quite relevant. And Alice, how do the regulations and in terms of the emerging technologies, how are they playing out in Uganda right now? Alice?
First of all, I think it's important to understand that we don't have a specific regulations for these emerging technologies. So we are trying to, both fields or these emerging technologies are being regulated with existing laws or new laws that have come up, like of course the Data Protection Act or regulations. But generally we have laws that govern the internet. That is where everything basically would fall. If you're talking about emerging technologies and you're talking about AI, definitely this is based on the internet. So we have, like, let me say 5 laws: the Information to Privacy Act, we have the Electronic Signatures Act, we have cybersecurity also laws, but all these there's nothing specific to these technologies. But at the same time, in case whatever penalties are under all the other existing regulations, definitely you would be caught on the wrong side and you'd have to pay heavily. The most specific one that would govern the emerging technologies is, of course, the data protection. And why? Because the use of these technologies means that you're using a lot of data. There are 3 sections that I think I briefly earlier on mentioned. It's mainly about the consent. It's all about, do you have actually the consent to use the data you're using, and then in case of breach, how soon or where and when you should report. And then lastly is the liabilities that would be the liabilities that come with a breach. And I mentioned the 2% and jail term. But generally, we don't have anything specific to blockchain, anything to do with robotics or AI and all that. Nothing specific.
Great, thanks, Alice. Are you envisaging any legislation of that particular nature coming forward in the near future, or do you think that you bulk up the existing legislation that you have? Actually,
recently, when was it? Maybe last week, we have a national payments bill that was passed by Parliament, but it's yet to be assented by the President of Uganda. And in there, it actually provides for regulation of electronic money. So we think it doesn't talk about blockchain and cryptocurrencies, but it's very specific in terms of what electronic money is. And of course, the definition in there, cryptocurrencies fall in there. And it's just been passed by Parliament. That's a week ago. We're waiting for it to be assented. So we are thinking definitely cryptocurrencies would be regulated in there. So that's the only new law that I guess is in the offing that, or is just about to be passed into law.
Excellent. That's great. Thanks, Alice. That's good to know. I think we're having the same sort of debates here in South Africa about the different types of technologies and how to adapt to the existing legislation to cater for those technologies, as well as whether or not we actually need new legislation to capture this very, very fast moving, technology era. Although I think one of the things that COVID-19 has done is it has focused the minds of those who have not historically adopted any form of technologies. It's brought the dinosaurs into the new age. So let's see, hopefully it will, all the new technology will continue to be adopted, and we'll see an increase in adoption over a period of time. Danielle, let us know what's happening in Cameroon.
Well, as I mentioned earlier, we enjoy the benefit of a comprehensive regulatory framework in Central Africa when it comes to fintech. Yes, and the law is very, very clear in terms of, the protection of users. We have a directive, a CIMAC directive on the protection of users of electronic communications. And that one puts forward the necessity of the CIMAC member states to do a proper screening, that is prior to, giving out the license or approval. There is in fact, as an operator, if you definitely obtain that authorization or that license, it means you actually stood the screening test. It's a very, very strict screening test that is being handled by the national regulatory boards. So you have the Telecom National Regulatory Board, and you have some other boards too that are competent to handle the screening. So it goes right from the top, actually. That is prior to the operations. The law has made it clear that for you to enjoy the benefit of that license, it means you actually stood the test. So that's the first point. When it comes to fintech operations, so to speak, when it comes to providing payment services through a mobile phone, that is on top of the previous licenses you actually obtain from the banking operator, or some specific, approvals applicable to the particular service or services you're offering, there is a specific authorization that applies to the technology to be used to provide the services through mobile phone. So in terms of regulation, yes, you need to make sure you actually, when you actually, cover the whole checklist. And that's what we see as protective in terms of measures for the users, actually. So for the user to start, to engage with an operator, he knows that if this operator got the license, it means the authorities actually handle the screening for me. So there is a specific, approval that applies to providers that intend to, put at the disposal of their customers services that have to be consumed through mobile phone. And also when it comes to the cybersecurity law and cybercrime law of 2010, it also makes it mandatory to all the network operators and payment services providers. It makes it mandatory for them to put in place very strong mechanisms to guarantee the security in the use of the various services, in the use of the various platforms they actually put at disposal of the consumer. So they are getting screened on a yearly basis, and the regulatory board also makes sure at the end of the year there is a report on the traffic of data exchanged through their platform. So there is that requirement that on a yearly basis they have to provide reports on the way the data is exchanged on their platform, on the volume of data that is exchanged, and also the various destinations of the various monies that actually transacted through the platform for at least a year. So those are, kind of restrictive measures that the law already provided for, and all operators, I mean, those that are licensed or approved operators within the smart zone, they are subjected to those laws, and this actually gives some assurances to the consumer when he has to transact or make a choice of the service provider.
That's great. Thanks very much, Danielle. I think it certainly seems as if the countries in Central Africa, and particularly Cameroon, have taken a lot of thought and are very mindful of the various issues that are arising because of the emerging technology. So that's really good to know. Fayaz, in Tanzania, what are we looking at in terms of regulations that protect users of these emerging technologies?
So just going back to the third question, the online meeting risks are also visible in this webinar. A friend of mine just sent me a message and he said that I'm going so close to the camera that the screen's about to burst. He said, sit straight, look at the screen like Christian Amanpour of CNN. Don't go close to the screen. Next time wear a tie. You are overloading your screen when you go too close. I mean, look at the kind of remarks you get instantaneously when you're in an online meeting. Yes. So let's go to question 4. So the laws that regulate emerging technologies in Tanzania, the first one is the constitution that provides the first line of protection for users on privacy and related issues. The second law that I can think of is the Cyber Crimes Act of 2015, which is a strict piece of legislation and criminalizes hacking, illegal electronic interference, data interference, computer-related fraud, and so on and so forth. Cyberbullying is also covered there, but also publication of false information is covered there. Third piece of legislation that I can think of is the Electronic and Postal Communications Law, which amongst others prohibits unauthorized access or use of computer systems, deletion or alteration of information. This law also prohibits the interception of communication, whether it's through a network or otherwise, fraudulent traffic, making or sharing of false information, including circulating content that may threaten public health. All that is prohibited. The fourth piece of legislation that I can think of is the electronic transactions laws that recognize online negotiations, e-signatures, and electronic payments, including, to a certain extent, digital money. The fifth legislation that has recently been amended, not that recent, but reasonably recently, is the Evidence Act, which allows parties before a court to submit electronic evidence to prove their cases, as is the case in other jurisdictions, obviously with certain limitations. And then we also have the Access to Information Act, which prohibits distortion of sensitive information, amongst others. And then you've got the Penal Code, which takes care of all the criminal issues that punishes, amongst others, frauds, false information, false pretense, and making false documents. So these are like an overview of the laws that, the regulations and the laws in our jurisdiction that protect users. We are reasonably covered. However, there is a decent protection under our laws. We are also going to be catching up soon. But remember what our mothers taught us, that prevention is better than cure. I think my mother is online, and this statement will make her very happy. But yeah, I think prevention is better than cure. Whatever you can do not to get into trouble, whether it is tightening your systems, making sure you've got proper IT infrastructure in place and you understand what you're signing for and into, I think that is where the first line of defense is, as opposed to trying to cure the mistake you did. Okay, so I think from Tanzania, that is it from us here.
Yeah, that's great. Thanks very much. So Nelly, if we can look at what's happening in Zimbabwe, but I think one of the things that you mentioned right at the very beginning, you spoke about telemedicine, and that's obviously an area that's relatively fraught with complexity, not only from a diagnostic perspective, but also in terms of data privacy. So in Zimbabwe, what are the regulations that, what are the regulations say in terms of protecting the users of these types of technologies? How are they protected? What are the requirements? And is there any form of criminal sanction that is used as a deterrent against the unlawful and illegal use of private and confidential information.
Thank you, Natalie. So as I had indicated before, I mean, all of our laws, I think as a continent, we are almost getting to a point where we have laws that are uniform, because we also have your protection of privacy. We also have the requirement, especially in the medical sector, for you to get full and proper consent from whoever is giving you medical information, and you even for research purposes. So when you say informed consent, you have to explain to the person who's giving you their medical information that I might process this and use it in order to obtain this kind of an objective. So it extends to much more than just receiving. I have to protect that information. I have to guard it because I'm required to at law, under the research laws, under the Constitution, under the information laws, even your census statistics, because you're collecting statistics, your Census and Statistics Act, and all those. What I wanted to take us to, because I like what Fayez was saying, prevention is better than cure. So my other user is your director, right? And I would want directors to be more prudent going forward. We have the new Companies and Other Businesses Act. We also have a national code on corporate governance, which requires directors to be far more than just your ordinary director. You have to be tech savvy. And so it means you have to know these things about data, whether you're a director of a hospital, a director of any manufacturing, a director anyway, you need to be tech savvy. What defense do you have, or do I have as a director, if I'm asked, this breach that has occurred, what did you do to make sure that you mitigate or reduce the possibility of the breaches happening, and what happens post the breach? Which means that as companies, you have to have policies in place that speak to the present laws, because you have to prevent those fines that are going to be imposed on the business, and even your personal liability issues. So you'll see that our Companies Act requires you to be more than just your ordinary director. Be prudent. The questions you are now going to have to ask your business is, what have we put in place to make sure that we are protected on a data security, data and cybersecurity level? You need to actually get expert advice, because it's not sufficient to just say, I asked the question. Get expert advice and expert guidance for the policies that you have to put in place. Now, because the other user is the person that you're providing a service for, we need to make sure that our policies speak to confidentiality, whistleblowing in a safe and protected environment, but without it being abused. What are the laws on hacking, or what are our policies on hacking? What are our policies on misuse of information, the personal information, confidential information? How are we going to treat harassment and bullying? And do we have a plan in place for remote deletion if our gadgets get lost or stolen? So this is something that applies to the user as a director, the user as a recipient in the medical and in any sphere or platform. So that's my contribution.
Great, thanks, Nelly. I think that brings us to the end of the presentations and the questions that are being answered. So the way that I see it is in three particular takeaways. So the one is know your app. Not know your client, but know your app. Understand exactly what you're getting into, what it is that you're purchasing. And it's like any other good or service that you're looking to purchase, be informed, know exactly what it is up front. The second takeaway, I think, is potentially know your law. What are the laws that you have available to you to use, whether you are the person offering the service or the goods, or whether or not you're the person receiving the service or the goods or purchasing the goods. I think those are quite important things to know. Where does it fit in terms of the legislation in your particular country, and what remedies do you have in relation to, as we say, cyberbullying, cybercrime, cybersecurity, data breaches? What are the kinds of things and the steps that you need to take to guard yourself against this, whether it be a claim in relation to liability from a user, or whether you yourself have had experienced some form of data breach or cybersecurity breach, or haven't actually in fact been asked for your consent. The other thing I think that probably goes back to something that we all were told, and I think the Americans have coined the phrase, is that there's no free lunch. So wherever something is offered to you free of charge, there is a very good reason for that app or the service being offered or the goods being given to you. So be aware of the value that is being derived from the other party in relation to the goods or services that are allegedly being offered for free. In our digital age and the age of technology, information is knowledge and knowledge is power. So those are things I think you just need to keep in mind. We have had a couple of questions that have come through. The first question that we got speaks to, it says, the currency was traditionally a store of value when it was backed by gold or silver, and we know now that the gold standard has been removed. This is currently not the case, and fiat currency is issued by a printing machine depending on monetary policy. Crypto is therefore not much different in terms of value, but it represents a serious challenge to the big players like the Federal Reserves. Is this a battle between both, which will lead to an eventual winner, or do you foresee them as being fiat currency and digital currency existing alongside each other? Alice, would you be kind enough to answer this question for us?
Well, I guess it's a war, like the question said, it's a real battle, because if you actually think about it, most of the Federal Reserves, most of the central banks, they're just worried about losing control. And it's only fair that actually they shouldn't lose control. But at the same time, I think it's important to find pretty much a balance, to understand the advantages that come with these digital currencies or crypto, and what governments or most central governments can, I guess, borrow from them, the benefits, that come with them, and try to, I guess, implement or adopt the concepts that are able to benefit all of us as, of course, the citizens. But in terms of them coexisting, of course, right now they're coexisting because so many people are using crypto without any central banks or governments being able to regulate or even to know what exactly is going on. So they are coexisting. It's just that one is existing at the mercy, not really mercy, because most governments are constantly issuing out all these notices that, warning their citizens they shouldn't involve in cryptos and all that. But at the same time, I know for certain there's some countries that have been warm about cryptocurrencies. Like, for example, Egypt. When was it? Last year, it made an announcement that they're coming up with regulations to regulate cryptocurrencies. I know in South Africa, I think it's more of what they call it. They're looking at it as crypto assets. But in Uganda, like I told you, right now, the National Payments Systems Bill or law that has just been passed by Parliament, in there, definitely I'm sure we'll be able to see more cryptos being, or cryptocurrencies and crypto assets more on the market and coexisting favorably. Who will win? I can't say. But the most important thing is that everyone, the people who use them, the huge benefits definitely they get from this. And I definitely always advise the government, but also when you come up with regulations of this industry, it makes it much easier for you to, keep in check of what exactly is going on. If the more governments run away from it, the more it actually becomes disastrous for them.
I think that's exactly right. There's another question here in relation to which significant commercial institutions have backed cryptocurrency. I can think of a couple off the top of my head. I know JP Morgan is definitely looking at is looking at their own cryptocurrency. Is there anything that anybody else on the panel wants to add in terms of who they've seen as significant commercial institutions actually backing crypto?
I think the Egyptian central bank is pretty much warm about it, and the only way when it made the announcement, it was more of let's regulate the industry and then be able to actually understand it. So for me, I think that was a very, very positive step. Globally, of course, many governments and banks have, like for example, in Malta, Bermuda, in China. I mean, at a global stage, of course, there are many institutions that have backed cryptocurrencies, but in Africa, not many governments.
There's also a lot of companies have also backed the tokens. So, they would have certain tokens that they would issue. So it wouldn't be generally, available for circulation. It wouldn't be something that would be published or issued by a central bank. So we're also seeing quite a bit in terms of the tokenization. We do have another question. It says, today, Google is facing a $5 billion lawsuit for tracking people incognito mode. But in Africa, we do not know or have capacity to know how individuals or corporates are affected by such breaches. In such suits, can Lex Africa be enjoined before the affected and future protection measures technically and legally? And Fayaz, I'm going to hand that to you.
So that's a very interesting question. Some people think the figure should have been higher than 5 billion, considering the amount of data that has been gathered. Now, the problem you see here is that whenever you open an incognito website, the company, whoever it is there, clearly states that the websites you're accessing will be able to collect your information. And are you agreeing to that? And then you obviously are in a rush and you say yes. So that's the contract, that you are agreeing to that. I mean, Google they will fight this till the end, because it is true that they have been gathering a lot of info, but the person has been agreeing to that also, because you're in a rush, you're getting a free advice, you're getting free websites to watch information online, etc., etc. So it's going to be a very interesting lawsuit. Now, coming back to our continent, first, trust me, Africa has built very good competence in this digital era. It has good competence. There is capacity for us as Africans to know what the hell is going on out there, because we have got, across and all over the continent, we have some very good capability. So the issue is, where has that contract been entered into, and the choice of law? So Lex Africa is a network of law firms. So yes, one of the law firms could be instructed to represent someone, but I don't think the law firm or Lex Africa would be enjoined itself. I don't think that, and that is for Lex Africa to comment on, but I don't think it would enjoin itself. Now, having said that, can someone, say in Cameroon or Zimbabwe or Uganda or Tanzania for that matter, join the suit? It becomes an issue of jurisdiction. It becomes an issue of the choice of law, whether there is arbitration stipulated there or whether it is court action. So it is a fantastic question, by the way, and someone needs to look at it further. But then the other problem we face here in Africa is funding legal action. In the Western world, there are big billion-dollar funds that will take a case, they will buy a case, and they will instruct lawyers. Because lawyers, unfortunately, and that's why they're not very liked, are expensive. Lawyers use their brain cells, well, they try to use them at least, to try and win a client's case. Now, in Africa, you don't see such class action lawsuits because there are no such lucrative funding agencies who are willing to fund the lawyers to pursue such action. But this is a really, really interesting question, and whoever wrote it is on the point, absolutely. But I may have answered your question to your satisfaction, maybe not. But the bottom line is that joining such lawsuits, the issue of jurisdiction, choice of law, there's a number of other factors that come in before you can actually join the lawsuit. And remember, it's a class action lawsuit. It's not an individual who's opened suit against Google. And someone, I was reading this morning, somebody said that it should have been $50 billion, not $5 billion. That's the amount of data that's on there. Yeah. Thank you, Natalie.
Yeah. Thank you. That's great. Thanks, Fayaz. I completely agree. I think 5 billion is a drop in the ocean, and I think it's not a hefty price for them to pay for what it is that they've done and continue to do. We have one last question, and then we're going to wrap up. The question pertains to data security, as in Tanzania, we are yet to have law or regulations taking care of personal data protection, if my understanding is correct. Under the circumstances, or what could be the options for us to ensure our personal data will be handled properly without being misused? Fayaz, I think this is probably one for you to answer as well. I think some of the things that we do need to consider, and I think this is definitely goes throughout Africa, is something that was mentioned earlier, is that what actually constitutes consent, and how can that be construed? If by ticking a box, does that mean that you know and understand what the conditions are? And if and can that then be construed as something that is a get out of jail free card for the person who's offering the goods or the service? So I hand over to you, Fayaz. Sorry, it seems to be for Tanzania.
Thank you. Again, a good question. There is no specific data protection law. I'm sure there is one in the making. However, when you look into our laws, the Constitution and the other laws and regulations under the TCRA Act, there is reasonable protection. And depending on what exactly the data has been used for and against, I believe there is average or above average protection, and it is getting better by the day. And I'm sure, as you have seen in other African countries and in the Western world, data protection acts are quite strict and stringent. We will be seeing that rolling out across the continent very soon. For example, I know lawyers who cross the border in Europe from one country to another, and because of data protection laws in the other country, they leave their laptops at the border and then pick up another laptop from the other side of the border, because data protection laws in the two jurisdictions are different. So I agree that there is no, like a data protection act that is 100% data protection act like the ones you see in the Western world. Yes, not yet, but there is adequate protection available in Tanzania under the Constitution and other laws.
Fantastic. Thanks, Fayaz. I want to thank all the speakers. Thank you very much for your contribution. Thank you for being here today. Thank you very much to the attendees for joining us. And we hope that you enjoyed the webinar, and we hope to host something again in the future. We look forward to hosting you. Please take care, stay safe, and chat soon. Cheers, everybody.
Thank you. Bye.